myself and Eleanor, we're both going to be talking about the Debt Respite Scheme and regulations and different aspects of that scheme. The talk's going to be in two parts. So I'm going to start by talking about the general rules that govern both types of moratoria that exist. That's the sort of standard breathing space moratorium and the mental health crisis moratorium. And then Eleanor's going to talk about that second type of moratorium and some of the recent case law that's considered these provisions. I mean, in the time available, these are quite lengthy regulations. I'm only going to be able to give an overview, I think, and highlight some of the key provisions, but there are some quite extensive notes that I think will be made available, if not now, then shortly after these seminars, where you can find more detail on the provision, on the provisions that are contained within the regulations. The debt respite and breathing space regulations, well, what are they? As Leslie said, they come from a statutory instrument, really, and you've got the reference on the screen. And the regulations are made under a power conferred by the Financial Guidance and Claims Act from 2018, which specifically contemplated setting up debt respite schemes after receipt from what became known as the Money and Pension Service. Part 1 of the regulations contains general provisions that apply to all types of moratoria, of which there are two: the breathing space moratoria, which are dealt with in Part 2, and the mental health crisis moratoria, which are dealt with in Part 3. Part 4 of the regulations are all to do with administration of the different schemes, and in particular, the requirement to maintain a register of what schemes are in existence and the debts that are brought within them. That's a private register, and so creditors who have debts included within moratorium schemes will only be able to see the details associated with their debts. And then Part 5 of the regulations provides for a review. The first review to be within 5 years, I think, of the schemes coming into effect. So sometime before May 2026, or this will be reviewed and maybe modified or continue as it is. As I said, these are new regulations. They only came to force in May 2021. So there's not much case law on them, but the government has produced some very useful guidance in two documents. The links will be in the handouts, but they can be found by searching online. The first is some guidance for money advisors, which form a very important part of these schemes. And the second is advice for creditors who are subject to some quite serious restraints as a result of moratoria when they're put in force. So with that general overview, start having a look at some key definitions. One of the key definitions is that of debt advice provider. Debt advice providers are really the gateway to the different moratoriums, and they're also the administrators of them. And they are people authorised under the Financial Services and Markets Act, to carry on debt cancelling activities for local authorities. And so, as I say, they are a pretty key component of these schemes. A second important definition there is that of a qualifying debt, and that's defined by what it isn't, and it excludes non-eligible debts. Discuss those in a bit more detail, but there's quite a long list of non-eligible debts, but still there are a lot of debts that fall in moratoria generally. And then moratorium debt, that's a qualifying debt that's owed in effect when the application for the moratorium is made. What are non-eligible debts? Well, I think the best thing I can do is refer you to Regulation 5.1, which has various subparagraphs A through to L that set out different classes of debt that don't qualify or that are non-eligible. Just highlight a few of them. secured debt, which does not amount to arrears, is a non-eligible debt. There's also a category of non-eligible business debts, which are again defined quite tightly by Regulation 5.6 to be debts that have been carried on or incurred in connection with a business carried on by a debtor, where the debtor at the point of the application for the moratorium is registered for VAT, or as a partner in a partnership with any other person, and the debt relates solely to business carried on by the debtor. That's potentially an important exception to be aware of. Several other exceptions, though, including liability, for example, to pay damages for negligence, nuisance, breach of statutory duty, in the case of death or personal injury, exclusions for debts incurred by means of fraud or fraudulent breach of trust. So analogous in that sense to the position in bankruptcy, where discharge doesn't release a bankrupt from liability of that type. There's exclusions for certain types of fine and perhaps and certain council tax and domestic rates liabilities, although some are included depending on exactly how and when they've been incurred. As I said, there's quite a detailed provision on that, but most of, many debts, I think as a general point, are liable to be qualifying debts, including things like credit and store cards, personal loans, payday loans, overdrafts, utility bills, and mortgage and rent arrears. And another interesting point, I think, is that joint debts can also be included, even if only one joint debtor applies for a moratorium. And then the enforcement action protections apply to both debtors in slightly different ways, but to some extent they apply to both. And of course, going back to that definition of moratorium debts, it's important to bear in mind that new debts incurred during the moratorium are not moratorium debts. So what's the effect of a moratorium? Well, that's dealt with in Regulation 7 primarily. And during a moratorium period, the creditor may not, in relation to any moratorium debt, take any of the steps specified in subparagraph 6, unless there's some other contrary provision in the regulations or there's permission granted by the court. What is prohibited by subparagraph 6? Well, there are four main areas. The creditor may not require a debtor to pay interest that accrues on a moratorium debt during the period, require a debtor to pay fees, penalties, or charges in relation to a moratorium debt during the moratorium period, take any enforcement action in respect of a moratorium debt, or instruct an agent to do any of the above. So there are quite broad restrictions on what can be added to moratorium debts, the enforcement of those debts. And there are also restrictions on contact with the debtor, which I'll come on to. So paragraph 6 or subparagraph 6 stops enforcement action. What's meant by enforcement action? Well, again, a common feature of these regulations is that you have a subparagraph with numerous subparagraphs in, and this one's no exception, has, I think, subparagraphs A to N that set out what enforcement action can amount to. Again, the definitions in the notes, but I'll give you some examples. Obviously, taking a step to collect a moratorium debt is prohibited, as is taking a step to enforce a judgment, obtaining a warrant. Starting action or legal proceedings is classed as enforcement action and therefore prohibited. Making an application for default judgment is prohibited, and as is serving notice to obtain possession on grounds 8, 10, or 11 of the Housing Act. And in fact, there are further restrictions that relate to gas and electricity supplies and taking steps to install prepayment meters. Any actions taken in breach of those of the requirements are null and void. That's the consequence. I mentioned earlier that there were some restrictions on contact. And again, they're quite wide-ranging. During a moratorium period, creditors and their agents can't contact debtors in relation to the enforcement of moratorium debts, save as permitted by a few quite specific exceptions. Those include contacting a debt advice provider regarding the moratorium debt, contact with the debtor for purposes unrelated to a moratorium debt, at the debtor's request to do with a complaint in relation to permitted legal proceedings, or if otherwise required to do so under the Consumer Credit Act or the Financial Services and Markets Act. So again, another restriction. And that's not the end of it for creditors. So they also have to notify any agents that they may have acting on their behalf as soon as reasonably practicable of the moratorium, and after they've received notification themselves. An agent, incidentally, is defined to include a solicitor under the regulations, and obviously agents can't take any steps that the creditors are prohibited from taking. They also have to search for other debts that should be included in the moratorium so they can be added to it. They have to search for assignees of debts and notify them of the moratorium. And a failure to do so can lead to a liability for losses caused to the debtor as a result. So these are provisions that creditors really do have to be aware of. And I think there's a lot of useful, as I said, there's a lot of useful guidance in the government publication online. So you might be thinking, well, there's a lot of restrictions. When can a court give permission to take steps anyway? Well, it turns out the court can't, in fact, give permission to take certain steps. That's to say, collecting the debt or enforcing a judgment or order. But it can, for certain steps, like enforcing security or obtaining a warrant. But it can only do so where it's reasonable to allow the creditor or the agent to take the step, and the step will not be detrimental to the debtor or significantly undermine the protections of the moratorium. So there's some quite high, I think, thresholds there to be met before permission will be given. But nonetheless, there's not a great deal of case law on that, on these types of applications at the moment. So I think that's probably an area that will develop over the next year or so. What about the effect on limitation periods? Well, if a creditor can't issue proceedings and the limitation period is about to expire, that creates an obvious problem. But there is a solution to that provided by Regulation 8, which provides for the limitation time to expire at the period of 8 weeks after the end of the moratorium, when there's a moratorium debt that expires, or the limitation period for which expires during a moratorium. What about other legal proceedings? Well, first of all, there's a requirement on the creditor bringing proceedings when they're notified to in turn notify the court of the moratorium. And there's a new practice direction that's been created to explain how that notification should be made. That's PD 70B. And what the court will do depends on exactly what proceedings they are. Bankruptcy petitions have to be stayed, and under Regulation 10.3, any other actionable proceedings which are pending at the start of the moratorium may continue until the court or tribunal makes an order or judgment in conclusion, but all necessary steps must then be taken to ensure that actions to enforce a court order or judgment do not progress during the moratorium. And so the prohibition is really on enforcement, and progression of enforcement includes holding a hearing, serving an order, warrant or summons, and so really it's very little that can be done in that respect. And there's many obligations on the creditor, but what about the debtor? Well, as I say, there's pretty significant obligations on a creditor, but a person who applies for a moratorium must first of all, take reasonable care to provide accurate information to the debt service provider and not deliberately withhold relevant information. And there are additional obligations in respect of breathing space moratoria, but I'll deal with that when I talk about those briefly. What about, or I suppose, what grounds are there for a creditor to request a review? I think this is a question that will be likely to come up quite often when these moratorium start being used more widely. Well, a creditor who's notified of a moratorium may request that the debt advice provider reviews it to determine whether it should continue or be cancelled in respect of some or all of the moratorium debts on one of two grounds. The first of those is that it unfairly prejudices the interests of the creditor, or secondly, that there's been some material irregularity in respect of eligibility, qualifying debts, or the ability to pay a debt and a request. So, that, I mean, just pausing briefly there, I suppose those grounds of challenge are equivalent to CVA type grounds, or at least analogous to them. And a request under Regulation 17.1 must be made within 20 days beginning on the start date of the moratorium, or when an additional debt is included within 20 days of the inclusion. Requests have to be made in writing and contain a statement of the grounds upon which review is sought and evidence in support. On receipt of a request, what does the debt advice provider have to do? Well, it has to conduct a review before day 35 and must cancel a moratorium in respect of some or all of the debts if it considers the creditor has provided sufficient evidence of unfair prejudice or material irregularity. But that's subject to a proviso that it doesn't have to take that step if it considers the debtor's personal circumstances would make the cancellation unfair or unreasonable. And there are various steps prescribed by the regulations as to how a debt advice provider has to approach this issue. One of the steps that, or approach this review, one thing they have to do is inform the creditor, obviously, of the outcome of the review and provide the reasons. And if the debt advice provider considers that a moratorium should be cancelled, it also has to consult the debtor and carry out various notifications, including notification in respect of the register. If a creditor is dissatisfied with the review, then it's back to the county court, and an application has to be made before the end of day 50 of the moratorium. And as I mentioned earlier, there's a new practice direction 70B, which provides guidance in respect of making applications that have to be made under Part 23 of the procedural rules. And there's also guidance about who has to be given notice of those applications. As I say, there is a review process. You have to go through the debt advice provider first, and if dissatisfied with that, it's a question of going to court and seeing if a court will take a different view. Now, the regulations I've been talking about so far apply to both types of moratorium. I'm now going to talk about one of the two specific moratoria, a breathing space moratorium, sometimes called a standard moratorium, and the provisions that apply specifically to this type of moratorium. As I mentioned, these are dealt with by Part 2 of the regulations, and a prerequisite to obtaining this moratorium is that a debtor has to take advice from a debt advice provider. And that means advice as to the suitability, conditions, and consequences of a breathing space moratorium. Once that's done, make an application then to the debt advice provider. Who is eligible? Well, there are three parts to the eligibility criteria. This is all dealt with by Regulation 24. First of all, there are individual eligibility criteria that the debtor has to meet. Then there are some additional conditions under subparagraph 4. And debts, or at least one debt, has to be a qualifying debt. In terms of individual criteria, obviously the person has to be an individual, has to owe a qualifying debt, be domiciled in England and Wales. There are various other requirements, but the main one to be aware of is that they can't have been subject to a moratorium in the past 12 months. And then the conditions that have to be satisfied are that the debtor is unable or unlikely to be able to repay some or all of their debts. And then secondly, that a breathing space moratorium would be appropriate. Now, how is it assessed whether or not it's appropriate? Well, again, there's some quite specific things that have to be considered by a debt advice provider and some other factors that may be considered, set out in the regulations. But the end result of those is that the moratorium period has to be necessary in order for the debt advice provider to assess which debt solution would be appropriate for the debtor, to advise on that solution and to put it in place. And a debt solution is an arrangement, scheme or procedure, statutory or otherwise, the aim of which is to pay, discharge or liquidate some or all of the debtor's debts. So the whole the purpose of this type of moratorium is really to have a chance to put in place a more permanent debt solution. And equally, because of that, there will be there are various examples that are given in the government guidance as to when a breathing space moratorium wouldn't be appropriate. And they include a person who can access funds or income who might be able to pay their debts with some budgeting help, a person who had assets that they could sell to clear a debt, or someone who could just enter the debt solution straight away without needing protections. How long does the breathing space moratorium last? 60 days generally, with a midway review between days 25 and 35. And very briefly, I'll just mention these additional obligations that fall on debtors in breathing space moratorium. They have to keep the debt advice provider up to date with any material changes in their circumstances. They have to make any payments that are due in respect of ongoing liabilities. Now, there's a very specific definition of ongoing liabilities within the regulations that's in the notes, but it doesn't include everything. And then they can't obtain additional credit that exceeds £500 cumulatively at any one point in time, and they have to keep engaging with the debt advice provider. So there are, as I said, the breathing space moratorium is a new tool, in effect, for individuals that need an opportunity to put in place a more long-term debt solution. And it's different to what Eleanor is now going to talk to you about, which are mental health moratoriums.
All right. What was Axnoller about? Well, it was a case about the mental health crisis moratorium under the regulations. You need to go and read the regulations if you've not done so previously. I've only had one case that has involved the regulations so far, a couple of weeks ago down at Central London. So it may be that not many of you have come across the regulations previously, but you need to go and read them and then have a look at the handout, which is very, very detailed. But basically, there was protracted and lengthy litigation between the parties. That's set out at paragraphs 3 to 12 of the handout. So you can go and read those at your own leisure. But the immediate concern was that Mr. Brake had entered into the mental health crisis moratorium on the 6th of May 2021. Pausing there for a moment, that's only 2 days after the regulations came into effect. So no doubt the applicant creditors thought that this was all just a scheme or a ruse to try and frustrate them. The applicants, who are referred to in the judgment in Axnoller as the Guy parties, applied to the court to, first of all, cancel the moratorium, and secondly, for unless orders regarding existing costs orders. There were 5 costs orders in total, which the court was concerned about, and 3 of those predated the moratorium, 2 postdated the moratorium. Okay. At paragraphs 14 to 21 of the judgment, the judge set out the rationale behind the purpose and structure of the regulations, and it's worth us considering those briefly. The Debt Respite Scheme had been a manifesto commitment of the Conservative Party at the 2017 general elections. I'm not sure whether any of us actually remember that, but that was the case. And then in October 2018, the Treasury published a policy proposal which set out two policy objectives for the Debt Respite Scheme called the breathing space. The first objective was to provide sufficient protection for individuals to help them to enter into a sustainable debt solution. And the second objective was to encourage more individuals to seek debt advice. There was an exception to the eligibility criteria, whereby those who were experiencing a mental health crisis would be entitled to use an alternative approach to access the scheme and to enter it. And the rationale for that, the reason for that, was because it was considered that it was difficult for people to engage with debt advice during a mental health crisis. As Nathan has explained, Part 3 of the regulations deals with the relevant provisions regarding the mental health crisis moratorium. So it's worth looking at that. In the judgment itself, which again is very clearly summarized in the handout, a judgment which spans 81 paragraphs. So I've got quite a bit to get through in the 5 minutes that remain. Anyway, the application was concerned by creditors for cancellation of the moratorium. First of all, under Regulation 17.1, a creditor must contact and make a request to the debt advice provider that the debt advice provider review the moratorium to determine whether it should be continued or cancelled. And there are various gateways into that, which are set out at Regulation 17.1, A and B. And that includes at Regulation 17.1A that the moratorium unfairly prejudices the interests of the creditor. Now, in this case, the applicant creditors had contacted the debt advice provider, and that request to cancel the moratorium had been refused. That request under Regulation 17.1 has to be made within 20 days, beginning with the day on which the moratorium started. So people need to get moving if they want to go down this approach. His Honour Judge Matthews, sitting at the BPC in Bristol, in his judgment considered a couple of preliminary points. First of all, should the application to cancel the moratorium have been made to the County Court or to the High Court? Regulation 19.1 says, and I quote, the creditor may make an application to the County Court on one or both of the grounds in Regulation 17.1. He said in his judgment that the County Court didn't have exclusive jurisdiction, that the High Court could be seized of a matter but would ordinarily remit it to the County Court unless there was good reason to do so. On the facts of this case, there was good reason to do so because of the already pre-existing and lengthy High Court litigation. So he said, High Court can be seized of the jurisdiction, so that's no problem. The second procedural issue that he considered was whether the application had to be made by a creditor by way of a claim form, or whether it had to be made by Part 23 application notice. Originally, when he gave his judgment, he held that a claim form should be issued. But then subsequently, in a postscript to the judgment at 12A, it seems as though the judge was referred to Practice Direction 70B, and in particular paragraph 2 of that practice direction, which provides that an application should be brought by way of the usual Part 23 application notice. So that's the procedural in by way of an application notice. Refer yourself to Practice Direction 70B if you want to. The arguments that were put before the judge by the applicant creditors circled around unfair prejudice. And the applicants argued that the moratorium caused harm by way of unfair prejudice within the meaning of Regulation 17.1A. And when considering that argument, the judge in Bristol decided and accepted that unfairness was to be judged objectively and that the court would have to carry out a balancing exercise. But he didn't set down any parameters for the future. He didn't really give any guidance for the future. What he said is that unfair prejudice should be given its ordinary meaning, and each case should be judged objectively on a case-by-case basis, basically making the point that each case was fact-sensitive. But the judge did opine and did observe that if the moratorium discriminated unfairly between creditors, so that the impact of the moratorium was significantly more severe on one creditor than another, that might be a proper basis to argue that there had been unfair prejudice to that creditor and might therefore give a jurisdictional weigh-in under 17.1A for the moratorium to be cancelled. The judge made 3 preliminary observations about unfair prejudice and creditors generally bringing these types of applications, and they're sat out at paragraphs 24 to 26 of the handout, which again you can read in due course. He considered aspects of post-moratorium conduct. So, for example, if there had been an improvement of the mental health of the debtor and the debtor then failed to engage, with the advisor whether that might constitute unfairly prejudicial conduct and therefore unfair prejudice to the creditor. So he wondered if that was a way in. Secondly, he considered, what about the elephant in the room, which he described as the elephant in the room? And what amount of money that was owed to a creditor would justify imposing the risk to the debtor of further harm to his or her mental health, such that the moratorium should be cancelled. And his view was, well, it's probably going to be the elephant in the room. You'll know it when you see it. His third observation was that pursuant to the application in this case, under Regulation 19.3, the applicant creditors had sought cancellation of the moratorium as a whole. Under 19.3, the court has the ability to make what's known as a tailored order. So it could cancel the moratorium in respect of one creditor or more widely as a whole, which was sought on the facts of this case. But the judge considered that the court should proceed with caution, effectively, if being invited under 19.3 to cancel the moratorium as a whole. The application as put by the applicant creditors to cancel the moratorium had a number of evidential issues. This is referred to at paragraph 37 of the judgment. And there was a lacuna, effectively, or the quality of the evidence was not good enough in support of the application. And the judge made the point that if an applicant creditor is applying to cancel the moratorium, there needed to be, and it was important to have evidence from a suitably qualified professional regarding, one, the debtor's mental health, two, the treatment that the debtor was undergoing, and three, the prognosis for the future of the debtor's mental health. And the quality of the evidence that was put before the court in this case didn't even begin really to address those factors, in particular, the long-term prognosis for the debtor's mental health. And it becomes quite clear, I think, when you read the judgment, that if an applicant creditor is going to apply to court to cancel the moratorium, you really need key evidence in that regard, and no doubt disclosure from the debtor in respect of the mental health treatment that they are undergoing and the long-term prognosis for any improvement of the mental health or any long-term consequences. And the judge held in this case, His Honour Judge Matthews, that there was insufficient evidence before the court in terms of the quality of that evidence. When considering the issues of prejudice, the judge did observe that the fact that there was ongoing litigation and that there might be further cost orders against the breaks if they lost in the litigation could potentially amount to unfair prejudice to, or could amount to prejudice to the guy parties, as known in the judgment. But what the judge said was that wasn't actually the effect or a cause or result of the moratorium. That was just the cause and effect of litigation as a whole, where people are litigating in civil action under the CPR. So he said, actually, that wasn't prejudice within the meaning of Regulation 17.1a, although he sort of observed that it could perhaps be considered prejudice in and of itself, but not under the regulations. There was also an argument advanced in this case that effectively Mr. Brake was using the moratorium for improper purposes, or there was bad faith that he was failing to engage with his advisor and so on. This, no doubt, as I said at the start, was motivated in part by the fact that Mr. Brake entered the moratorium some 2 days after the regulations came into effect. But the judge rejected that bad faith argument. He said that he couldn't find any evidence of that and was not satisfied that that was made out on the facts of this case. In terms of the cost orders and the point that I'd raised at the start of the seminar, there were 5 cost orders in total, and the applicant creditors sought unless orders in respect of all 5 of those, with debarring provisions in the usual way. The judge considered that the pre-moratorium cost orders were moratorium debts for the purposes of what Nathan has already spoken about, and he decided that those were not capable of being enforced, in inverted commas, by way of an unless order because of the fact that those debts were bound in within the moratorium. But the cost orders that postdated the moratorium, those he considered were not bound within the moratorium, that he rejected the Brake's arguments that future debts were covered by the moratorium. And he decided that the post-moratorium cost orders were in fact not covered and therefore could be enforced by way of an unless order. In that regard, therefore, he took the view that it wasn't asserted by the Brakes that they weren't able to satisfy those post-moratorium cost orders, but that they had taken a deliberate view not to pay them. And in those circumstances, he imposed an unless order, deciding that those cost orders were not bound, were not covered, did not fall within the moratorium, therefore could be pursued and could be the subject of an unless order, such that if the Brakes didn't pay them, then there was a strikeout sanction. The judge also considered in the alternative to whether he should cancel the moratorium, whether he should impose a stay upon the moratorium. And he deals with this at paragraph 81 of his judgment. He decided that a stay of the moratorium would effectively enable enforcement by the back door, and that would contravene the whole purpose of the moratorium itself, which was to give people who needed a respite from being pursued from their debts a break effectively, and that if the stay was imposed, that would lead to effectively enforcement by the back door. So he said no to the stay, no to cancelling the moratorium, and he decided that actually, on the facts of this case, the applications by the creditors would be unsuccessful. What do we glean from the case then, really? I think there is very limited case law at the moment. As I say, I've had one hearing in London that dealt with the breathing space regulations. And that hearing, we had a lot of argument about what meant by enforcement, what the court took the view that enforcement was, and effectively the hearing ran out of time and we got adjourned before the judge had to make a decision. So I suspect that many of us probably will encounter these arguments in the future if we haven't yet encountered them. I think from Axnoller, we take a few points. First of all, an application to cancel the moratorium will not be easy, and it was rejected on the facts of this case. Secondly, if you're for an applicant creditor, what kind of evidence do you need? Well, you certainly need to build your case around, it seems to me, the long-term prognosis of the debtor's mental health and the ongoing treatment, because otherwise you're going to be met, I think, with a judicial response, which is, well, where's the evidence that suggests that there will be an improvement of the debtor's mental health, and therefore that the moratorium should be cancelled? In that regard, and obviously we now accept, I think, that you don't need to bring a claim form, you bring an application under Part 23, but you need to have regard to the quality of the evidence that you will need to obtain in due course and the disclosure that you will need from the debtor if you're acting for an applicant creditor who wants to apply to cancel the moratorium. And the salutary lesson on the facts of this case is that there wasn't that quality of evidence before His Honour Judge Matthews in Bristol. The third point that we take from the case is that when you are considering what steps to take and considering how best to put some pressure on parties, you will consider, I think, which debts are moratorium debts, which Nathan has already touched upon, and which debts are post-moratorium debts and are therefore capable of being enforced or pursued. And that was the point about these post-moratorium cost orders, that the court was able to consider that future debts were not covered by the moratorium and therefore were capable of being bound by an unless order with the usual consequences and debarring provision. All right, that's been a whistle-stop tour through Axnoller. The handout, as I say, is very comprehensive, but after receipt of that, if you have any questions at all, I'm sure Nathan and I would be absolutely delighted to answer them.